Good afternoon, everyone. Justice Bright, this is the October 6th meeting of the Superior Rules Committee of the Superior Court. Lori, I'd ask you to go ahead and take the attendance to make sure we have who we have present.
Sure, I'd be happy to, Your Honor. I'll mark Your Honors here. Judge Aaron.
Present.
Judge Armada.
Present.
Judge Doyle.
Here.
Judge Green.
Here.
Judge Griffin.
Here.
Judge Maturowski.
Here.
Judge Torres.
Here.
Judge Welch.
Here.
We have quorum, Your Honor.
Thank you. Thank you, everyone. Good to see you all. I'll just note, as usual for these meetings, we're being streamed live on YouTube, where everyone can follow along with what we are doing. We also have a number of other people who invited guests who are here relating to various proposals that are on the agenda. The first item on the agenda is the approval of the minutes from the September 8th, 2025 meeting. Is there a motion?
So moved.
Judge Armada moves. Is there a second?
Second.
Second. Nope.
Judge Torres, I think that was. Any discussion? All right. All those in favor of approving the minutes signify by raising your hand. Any opposed? Any abstentions? Okay, the minutes are approved. All right, the next item on the agenda is a proposal for requirement that attorneys who use AI programs to conduct legal research, such as ChatGPT, append a certification to their pleadings and/or briefs that they have independently verified the accuracy of the citations therein. This proposal had been referred, had been on previous agenda and had been referred to the AI committee for their review and any comments. Judge Armada, as a member of that committee, do you want to provide an update?
So the AI committee has been working independently from the Rules Committee, but sort of in tandem. Last year, the AI committee got a presentation from various stakeholders, including judicial information technology, about what AI is. It's sort of hard to try and put our arms around this thing without first understanding it. That being said, I was lucky enough to have a meeting with Justice Bright and Justice Alexander to sort of talk about what we're seeing. Some of the earlier thoughts from some of the jurisdictions were to put out bans against AI, but AI is being built into all our technologies, all the program, Microsoft, things like that. And so some of the bar associations took the position, don't limit it because you're limiting things that are already there and it's too hard. So with that, Justice Bright came up with a great idea and actually took the lead in drafting to propose a rule to the practice book that would require certification that to the extent artificial intelligence programs or products were used, the profferer is independently verifying the accuracy of the information contained therein, so we're not getting fake case sites and things like that. There was also a discussion in terms of some of the deep fakes we're getting for next time and talk about where it could land. I would be thinking it would land in section 4 of the practice book in the pleading section on certification.
Yeah, I've not circulated it to anyone else yet. I kind of wanted to get a sense from the committee whether this was something that anyone felt was worth pursuing from a concept standpoint. The other thing that we had, when we had the meeting, we talked about what other jurisdictions are doing, and a number of federal courts, including District of Connecticut, are requiring people to certify if they used AI in the drafting of their filing. I'm a little bit concerned about asking people to certify that because it's unclear to me, particularly as AI continues to develop, whether people will understand whether they have in fact used AI. Westlaw is a form of artificial intelligence. And what I was thinking is we ask someone to certify that if they use artificial products or programs, that they certify they've independently verified. So that way, I mean, it's an obligation for all lawyers to independently verify anyway, but this would also cover self-represented parties. And I think we might also want to consider adding on to that a kind of disclosure that, or an acknowledgement that they understand that if they do not independently verify the information, they may be subject to court-imposed sanctions, including the possible entry of a non-suit or a default judgment. That, again, focus as much on self-represented parties as attorneys would let them know that this is serious and that they put themselves at risk if they're just relying on things without verifying it themselves. The other thing that some states have done is the deepfake issue that Judge Armanda mentioned is a significant one, but I'm not sure whether that's something that gets done in the rules of practice or gets done in trial management orders, where people are asked to identify their evidence that they're going to put in at trial and identify whether it's real or not. There's at least one jurisdiction has a process if someone reasonably believes that that some of the evidence is a deep fake, they can challenge it in some way. But that to me seems that might be different than what we would deal with as a rules committee. The last thing that some jurisdictions have done is they have made changes to their professional rules of conduct to make it clear that not verifying this information would be a violation of the rules of conduct. I mean, I think it's already, I don't know that that's necessary. I'd be interested that, obviously what all you want to do on that. But if any attorney put in fake citations, no matter whether they came from AI or their child or an associate who was making it up, they would still be subject to the rules of professional conduct. So, but that would be another avenue that we could pursue if we thought that adding something explicit in the rules of conduct would work. And some states have done that and built it into their rules of professional conduct, as opposed to doing a standalone rule of professional conduct on AI. So having said all that, is there any, and does anybody want to weigh in on this or discuss it in some way?
One thing that I'll add is that in talking with the Connecticut Bar Association, the thought leaders in this area, jurisdictions that tried to clamp down on AI were finding that it was also impossible, given that it is developing so fast. And you build a rule for X, and then they've developed Y, Z to the nth degree, and suddenly that rule is antiquated, and then it was harder to repeal type thing. So this was less is more, just verifying the accuracy, which seems sort of common sense, but with hallucinations, citations and things like that, this is putting the onus on lawyers and people who appear in front of the court. I'll also note that in bigger firms, ethically, they're talking to their attorneys and their associates about that, about double checking the work that's been produced by like a ChatGPT or something like that.
Judge Green?
I was just wondering if anyone is aware of any of the dedicated legal research sites. So I know that AI is involved in Westlaw, for instance. Has Westlaw ever been known to hallucinate a site versus ChatGPT?
I didn't think so, because Westlaw is a closed environment. Right. So when you use their new product, as I understand it, where Westlaw will generate a memo for you, they are doing it solely based on the information that's in their system, which are verified cases and treatises and so forth. So I think that's a difference between a closed system and an open system. And I'm probably not using the right terminology, but that's kind of, I think, the difference. Does anybody else know anything about that?
It also depends on the scope of the program you're using. So Westlaw is designed for research, and as Justice Bright said, it's picking up, verified treatises and case citations and things like that. ChatGPT and programs like that go outside, and they're looking at sort of the whole internet, which then suggests to the user part of this is user engagement. They want to keep the user engaged. So I'm going to show you what you want to see to keep you engaged, which is where you start getting the hallucination effect type thing. So if you're asking ChatGPT to help me find cases that do it, it's going outside that Westlaw system. And therefore it's going to say, oh, green versus green is the perfect case for you. And, you know, and create something.
Anyone else? Judge Mazurowski?
So just anecdotally, unfortunately, we have seen this come up here in Tolland mostly in some civil cases, and both lawyers and self-reps. So I think a rule that, applies equally makes sense. And in one case, it was an out-of-state attorney who then immediately withdrew when the issue was raised. So the ability to address it became an issue. And then in at least one, we have had a self-rep. So I think the certification makes sense. It's too bad that, certainly for lawyers, you would like to think you don't need it. But I think a certification to at least highlight the issue is appropriate.
Anybody else? Judge Griffin?
Following up on that point, it seems like part of what we're trying to attempt here is to get word out and notice out to the parties to be aware of these hallucinations and the like. The one concern I have with the certification is that the lawyers and the parties who know to put the certification in are probably the lawyers and parties who will also know to check for the hallucinations. And those who don't put the certification on when they use it are likely also probably not to be aware of the possibility of hallucinations. So my one concern with the certification is it might not ultimately accomplish what we're looking for unless there were a requirement to put it on all pleadings stating that if it was used. Of course, then we run the risk of we're going to start rejecting those, and what kind of difficulty is that going to cause at the clerk's office? So
yeah, no, my thought was it would be a certification that would go on all pleadings, and that the clerk's office would just be asked to look for it. And if it's not on there, particularly with respect to self-represented parties, they would say to them, hey, you have to put this certification on that you didn't use artificial intelligence, or if you did, you checked, or you have to put the certification on that if you used artificial intelligence, you checked to make sure everything was accurate. You're right. It may lead to some rejected pleadings, and it may also lead to people making the certification when they didn't actually do what it said. But that's why that's why I thought it might be helpful to put the sanction language on there as well. So they know that,
especially if that's in
consequence.
All pleadings, that would make a lot of sense if that's required in all pleadings to get the awareness out.
Anyone else? So, then it sounds like there would be interest in seeing proposed language on this topic. And if that's the case, I can work with Judge Armada, and we can present something at our next meeting. I would probably, once we have the language submitted, want to refer it to the CAJs to see whether they think it creates any problems or whether it accomplishes what we're seeking to accomplish, and whether there's any difference from one area to the other. Okay.
We'd probably also want to send it out to the Connecticut Bar because they've been our partners across the aisle on it as well.
Agreed. Yep. Okay. All right. So we'll put something together and submit it. So we'll have it to review at the November meeting. Let me just ask on the other piece of this is the rules of professional conduct, and whether there's anyone thinks that that's something that you want to look at as well. And there was in the materials that were on the agenda an example of, I'm trying to remember whether it was Pennsylvania or another state, that it just added some language in their rules of conduct explicitly referencing AI, but not creating a separate rule with respect to AI. I don't know if anybody wants to take a look at that or has an interest in looking at that and maybe proposing or letting us know whether you think you want to propose any language for changes to the rules of professional conduct. All right, I'm not seeing anybody expressing a strong interest or desire in that. So what I'll suggest is take a look at those materials again. As I said, there's a summary that goes state by state, and there's one state that had some suggestions. They modified their rules, and it'll show you the precise changes. And then we can discuss that at November meeting as well as to whether we want to pursue that in addition to pursuing this certification course on pleadings. Okay. Yes, Judge
If I may
Griffin.
follow up on that, one thought I had was whether even if there's not a new rule adopted or language added to a rule, whether at least putting something in commentary that AI hallucinations are considered part of an attorney's duty of candor to the court and the like.
Yeah, I was thinking the exact same thing, that maybe a comment referencing it would be enough to kind of call people's attention to it.
The one issue with commentaries, and we're going to talk about this towards the end of the agenda, is the commentaries don't stay in the practice book year after year. We typically only put commentaries in when we make a rule change, and then the commentary usually stays in just for a year unless we say that we want it to stay in longer. Lori, did I accurately describe the usual practice?
Well, except if we're talking about the rules of professional conduct and the rules
those
of
commentaries
judicial
stay,
conduct,
yes.
those do stay in. And those are rules which the judges would vote on and refer to the Superior Court judges for a vote on. Yeah.
So that may be the way we deal with it. So maybe Judge Griffin or Judge Mazurowski, if the two of you want to take a look at the rules of professional conduct and decide if there's commentary language you want to propose.
I'm happy to
Sure.
help you with that too.
Sounds good.
Thanks. All right. Anything else on this topic, which also encompasses the informational memorandum, which is 2023-014 on the agenda? Okay. Seeing nothing else, we'll move to 2024-013, which is the proposal to amend discovery rules and summary process matters. This has been on the agenda for a while. It had been referred out to a number of groups, including the Access to Justice Commission. The Access to Justice Commission met on October 1st to discuss the matter. At that meeting, there was a interest by the proponents of this rule and the operations group in the judicial branch to work on modified language that would incorporate recent changes to Connecticut General Statute 47-3A, subsection D, which requires the production of the ledger upon request by the tenant. I believe Attorney Shea is in attendance today. There's going to be work on modifying that proposal. So the Access to Justice Commission had nothing to report at this time. I believe Attorney Shea would prefer that we not act on this proposal because there's likely to be a modified proposal. Is that correct?
That's correct. Thank you, Justice Bright.
Okay, so we will have this go off the agenda for future meetings in anticipation of a new proposal being submitted. And whether that will be for the November meeting or the December meeting kind of depends on how the process goes. There's another Access to Justice Commission meeting scheduled for November 12th, where whatever work is we'll get an update on whatever work is being done. And if it happens to go more quickly than that, maybe we'll have something for our November meeting, but we will keep you all posted. Anybody have any questions on that? Okay.
Thank you.
2024-016 and 2024-020 both deal with proposals for adding rules for the use of names and pronouns for attorneys, parties, and witnesses. There was a subcommittee that had worked on specifically 2024-016. There was a proposal that was made to modify by the subcommittee to modify 3.1 and 3.1 and 3-3 of the practice book. We had this go over so all the new members would have an opportunity to review this. And it's the next up on the agenda. So is there anybody who wants to discuss it or make a motion?
I'll discuss it, Mike. First, the concern I have is the second sentence, because it talks about if a designated form of address is indicated in an appearance, the judicial authority shall, and I understand in the commentary, shall has not been, is not mandatory. However, in practice, you wouldn't be alerted to an appearance form. And I say that this morning, I had a number of hearings and I would never look at appearances. And then I'm thinking of my days in the GA and those in the GA who don't even see a file. So I don't know how in practice it would be implemented. So I don't know if that had been addressed prior to our review today. And so maybe it's an idea, or we send it to the CAJs to see what their input is as to implementation of the second sentence.
Judge Green?
I was on that subcommittee with Judge Chaplin and Judge Pearson, and we were all aware of the fact that the court is not necessarily aware of what's on the appearance. So I think that it would be a matter of kind of getting folks used to, if it is in the appearance, for instance, the clerk looking at the file would have to be brought to the court's attention. I mean, that would be a change in the same way that adding it to the appearance in the first place is a change. So, and clearly that makes a difference to the folks in front of us, but it would require some slightly different procedures, I think, in court. But I think we did take that into account in trying to find a way that somebody could add this information that they wanted their pronouns addressed to avoid misgendering, but in a way that everyone would see it and know it sort of instantly. We couldn't come up with something. And so the appearance form seemed to make the most sense, but we'd have to discuss it or be brought to the court's attention in each case.
Judge Griffin?
It would seem that the solution to that probably might lie in technological upgrades and sort of upgrading what we see in Edison to provide those alerts or prints on the criminal dockets or the like, to make sure the court becomes aware of it, because as mentioned, we often don't see the appearance forms. And with that, even if the commentary indicates the word shall is directory rather than mandatory, I wonder if the actual language in the rule should still read as strongly with shall.
Anyone else? Judge Armada?
Jenna Cutler is online, I see, but I'm looking at her last submission where they added each appearance form may include the individual attorneys or parties' preferred pronouns. Courts must use the individual name, and I'm troubled by the word must in that. When you've got a busy docket and you're trying to maintain decorum and things like that, we try to be conscientious of it, but what happens if a judge slips up and uses the wrong pronoun? What does that do, type thing? So I was troubled by that word must, and that looked to be like an addendum that she wanted to add to this.
Can everybody hear me?
Oh, Attorney Cutler, go ahead.
Thank you. I understand, Judge Armada, I understand your point with the word must, and I wouldn't have said it was an addendum that I was adding. I don't believe I've submitted anything since the initial proposal of the rulings, whether or not, it was provided additionally. Again, it has not been from me. So I'm not looking necessarily to include the word must. I don't think there should be, a sense of punishment should anybody accidentally use incorrect pronouns. I think the purpose was that there have been attorneys across the state, along with parties across the state, that have been, intentionally misgendered by either the court or opposing counsel. And it was a way to either have the persons before the court be addressed with their correct preferred pronouns or addressed in a gender neutral way, such as opposing counsel or, witness, defendant, something that's not going to intentionally cause this additional stress on the parties or counsel or, whichever person requires it. If that makes sense.
Anyone else?
Justice Price, so following up on those, because I mean, we have some hearings where you don't have a clerk. We have most of our hearings on the civil side don't have a judicial marshal. And maybe it is something to, whether to the committee or the CAJs, to the line judges of, hey, our concern is the implementation of it, not with the first sentence, but the second sentence, and how is it implemented so that the court becomes aware of it? Is it the responsibility of the person who has the appearance to bring it before the court? So I'm just concerned that we have these appearances that are, as I said, in files that aren't. How is it brought to the court's attention? That's obviously my concern.
Yeah, I think there are two pieces to it. One is, how is it brought to the court's attention? And second, what happens if the court's just unaware of it? And I think the second issue, the first issue is really an implementation issue unrelated to the rule. The second issue is more a rule-related issue in terms of the language. And I think you might be able to solve that by saying, in the second sentence, if a designated form of address is indicated in an appearance and the judicial authority is aware of the designation, the judicial authority shall use the individual's name, the designated citation, and so forth. This way, that would seem to me to address the concern of an intentional misdesignation or misidentification, but also provide a cover for a judge who, it's been a while since I was in Superior Court, but I never looked at the appearance forms before I went out on the bench. And certainly in the GA, where you don't have appearance forms for criminal defendants, they're there with counsel. I think we need to make sure that the judge is aware. But if the person says, Judge, I'd like to be identified in a certain way, and the judge says, I don't care what you want, this is my view, I think that's a problem. But if the judge says, oh, sure, now that I know you want to be identified that way, that's how I'm going to identify you. So I think that the language piece might solve the how do we not punish a judge or criticize a judge for something they didn't know, and then how it gets implemented. If we adopt the rule, that would be more a question for what the CAJs, or how they would implement it, and whether it's a reasonable way. Is it reasonable for them to implement something like that? So we might want to ask them for their input on that. And I don't know, Lori, if that has ever been asked before of the CAJs.
This doesn't answer that question directly, but I did want to tell you Becky Schmidt from Court Operations is on this call, and she may be able to shed some light on that question.
Okay, Becky, we put you on the spot.
Thank you, Your Honor. Just briefly regarding the file itself and how it would show for rule implementation if it were to pass on our end. It just depends on what the direction is. We would, appearances are system populated forms and e-services. So unlike a form that you fill out and you scan and upload at the clerk's office, or that an attorney e-files a PDF of, the system asks the question and prompts for a response, and then creates the form itself. So whatever's entered on the appearance form is what would show in the party display. So it's just a question for court operations. It would be a referral to our BPAT. It's business process and something unit. I forget the full acronym, but we would discuss how to implement that. If the changes were just language in the input pages, which we've seen before, I've certainly seen law firms file, Ms. Schmidt for the plaintiff, Ms. Rebecca Schmidt. So they can put that in if they'd like to. Right now, there's nothing in the system that prohibits using your preferred But that's usually off of the complaint. So we understand that the plaintiff may not necessarily properly identify the defendant how they wish to be, referred to. So that would be something, if it was a free form, that would be easier for a build. If it was a required element that needed to be part of the drop-down menu, we would obviously need direction as to what terminology should be included. Then that would be more of a technical build to include the new data elements, but those would all pull to the party screen. So as a judge sitting before the court, as long as they've selected what they'd like on that appearance, you should see the identity listed as part of the party screen. So however the direction was for us to do so, we did believe that it could be done with a fairly simple build, or if necessary, a more expansive one. We would just need time to implement it.
Anybody else have anything they want to weigh in on?
Justice Bright, I just received a note from one of my colleagues. We don't believe that this was referred to the CAJs. So if there's any questions about implementation, you certainly could refer it to the CAJs as well as court ops.
Is there an interest in referring this to the CAJs regarding the implementation question?
Justice Bright, I would have an interest in that, and with your proposed, and I don't know how the rest of the committee feels, but with that proposed amendment that you had as well.
All right. So let me just ask Judge Green, since you were on the subcommittee, the suggested language or the language that I suggested about, the judge being aware of the designation, do you have any concerns about that being added to what your subcommittee proposed?
I do not, but I mean, I'm wondering if there are means of just making sure that the court is aware of it. I agree with Judge Griffin that, I mean, could it be built into Edison where you would get a note in the same way that you get a note in a family file indicating that the parentage documents haven't been filed yet? That's something that would sort of flash, listen, something has been filed here. And the difficulty is in criminal, where no one ever sees the appearances. So, I mean, I think before the technology change, if that's something that we wanted folks to pursue, I think it's fine if the judge is not aware of it. But as soon as the judge is aware of it, then the judge would have a responsibility to use the pronouns that are requested and and not misgender that individual. So I think the added language is, at this point, I think helpful.
Okay. So would you all like us to ask the CAJs for their comment on it with the additional couple words that I suggested? A yes?
Yes, that's fine. That's good.
Consensus that we do
Yes.
that? All right, then we'll do that. We'll make referral out to the CAJs, adding in a couple words to the second sentence that would say, if a designated form of address is indicated in an appearance and the judicial authority is aware of the designation. So that would be the additional language, and the judicial authority is aware of the designation.
Justice Bright, how about erring on the side of caution and just taking a motion on that amendment
Sure.
language?
So
Can I maybe make a comment first? I'm just wondering whether it would be helpful to say, and the judge is aware of the designation or otherwise becomes aware of an individual's preference, who's appearing before them preference. I guess to get at the fact that appearance forms don't cover everybody who is appearing before a judge. There's discussion about criminal cases in particular. So I didn't know if that might be helpful.
Yeah, I agree. I thought it should be made aware or something, because I come from the criminal background of thinking like in the Bridgeport GA when I started, and we just never saw, like everyone said, we don't see the information. So it's usually dealt on a kind of case by case basis.
Okay, so we'll take that as a motion by Judge Mazurowski to amend the language to include if a designated form of address is indicated in appearance and the judicial authority is aware of the designation or otherwise becomes aware of
Like an individual's preference,
designation preference.
right?
Okay. That's motion from Judge Mazurowski. Judge Doyle, are you seconding that motion?
Yes, sir.
All right. Any further discussion about the amendment? And again, we're not voting on the proposal today. We're just voting on what we're going to send to the CAJs for comment.
Just a point of inquiry. I'm looking at Attorney Cutler's letter that came in on February 10th. This is addendum F, where there was a sentence language added. Each appearance form may include the individual attorney or party's preference pronouns. Courts must use the individual name. That's not part of the suggestion from Judges Chaplin and Green and Pearson. And I just want to make sure we're sending the right one for consideration.
That's correct. My understanding is that that was the proposal that was made. It went to the subcommittee and the subcommittee came up with this particular language, substituted shall for must, and made the other suggested changes, and Attorney Cutler is nodding in agreement with that.
Yes, I agree.
Okay.
All right. So any further discussion on the proposed amendment and that we send it to the CAJs? All right. All those in favor signify by raising your hand. Any opposed? None. Any abstentions? None. Okay. It's unanimous. It'll get sent to the CAJs for comment, particularly on the implementation. Lori, you.
Do you want a referral to court operations or just the CAJs right now?
Let's get it to court operations as well.
Okay.
I think since they're the ones that actually have to do the implementation. If we're doing it along the lines that Becky had suggested.
Very well, thanks.
There was also the proposal 2024-020, the proposal for the adoption of rules concerning the use of names and pronouns for attorneys, parties, and witnesses. Does anyone think that particularly given that we are talking about amending the rule as suggested by Judge Mazurowski, that we need to do anything else with respect to that item? So does anyone think we should just table that until we see where we end up on 2024-016? Someone want to make a motion to do that? Judge Griffin?
So moved.
Is there a second?
Second.
Judge Mazurowski, any discussion? All those in favor of tabling 2024-020 until we address 2024-016, raise your hands. Any opposed? Any abstentions? All right, that passes unanimously. All right, 2025-002 is next on the agenda. And this is a proposal to repeal practice book section 16-12 and to add a new rule, section 15-9, that provides procedures where the trier of fact, whether by judge or jury, may conduct a review of place or thing involved in a case. Judge Bellis, I think, was on the call. I don't know, Judge Bellis, if you want to comment on this at all.
Yes, thank you, Justice Bright. So we were trying to get a handle on out-of-court inspections and viewings, because there are considerations such as accessibility by jurors and staff and liability issues, and in housing cases, even biohazard issues. And then we discovered that the practice book addressed jury trials, but not viewings or inspections by in bench trials. So that was interesting, and especially because most of the viewings and inspections are done in courtside matters. So we simply proposed adding in the trier of fact, which would cover jury and courtside. And I did see, I mean, it's pretty self-explanatory. We added in some guidance as to when it should be done, because they're really, you know, when the judicial authority is of the opinion, doesn't really provide much guidance. So we added in some proposed language. I believe Eleanor Sterling had proposed a little tweak to that I was in agreement with. So I think that's pretty much it if you have any questions.
Do we have any questions for Judge Bellis? All right. Thank you, Judge Bellis. Good to see you.
You as well.
All right. Anybody want to either discuss or make a motion regarding the proposal?
I move to approve.
Who was that, Judge Doyle or Judge Griffin?
Welch.
Welch, sorry.
Welch.
All right, there's a motion to approve it. And is that the proposal as amended by this CTLA?
Yes.
Okay. Is there a second?
Second.
Judge Griffin?
I'll second. That was going to be my question, was which proposal.
Oh.
So thank you for clarifying.
Okay.
And I'll second.
Any discussion? All right, so the proposal is to remove section 16-2, replace it with 15-9 as proposed by Judge Bellis, as amended by the proposal of the Connecticut Trial Lawyers Association. All those in favor signify by raising your hand. Any opposed? No. No abstentions. It's approved unanimously.
Your Honor, just a little technicality. It's approved unanimously to be sent to the public hearing.
Yes, thank you. Yeah. All right, the next item on the agenda is 2025-009. This was the proposal to amend section 7-19 to specify that a self-represented litigant can subpoena witnesses to depositions. We had comments from Judge Bellis that suggested adding the word deposition into 3 spots in the practice book rule to make it clear that it applies just not to trial testimony, but also to depositions. Judge Diana comment that I don't know that he saw Judge Bellis's proposed changes. I think he was commenting more on the original proposal, saying that he thought the rules covered it. And I think a lot of us thought that, sure, if a self-represented party wanted to depose someone and came in and explained the reason for it, and there was a need for it, and the judge determined there was a need, the judge could give a deposition subpoena. But the rules aren't explicit in that, which is why I think Judge Bellis made the proposal. So I don't believe Judge Diana's opposition was to what Judge Bellis was proposing so much as to something more broad that he thought someone was suggesting. So with that, does anyone have anyone want to discuss this or have a motion? Judge Aaron?
I'm just curious, and I could be missing something, as to why section 1326 and through 1328 wouldn't cover this. Why there needs to be a change.
Judge Griffin?
I had the same observation, because it looks like in 1328, the court can, upon request, issue a subpoena for a deposition as long as certain procedures are followed in 1326 and 27. And in those sections, any party can follow those. It's not limited to counsel. And I've had situations where self-represented parties have asked for me to issue deposition subpoenas in the past. So I know our clerk's office has facilitated that.
Anybody else want to be heard on this? Trying to go back to the proposal here.
It looks like Judge Bellis might want to respond or comment
Yeah, Judge
on.
Bellis, did you want? Yes, go ahead, Judge Bellis.
Thank you. Our forms were confusing. I think that's where this originated. While certainly judges would issue the subpoenas for witnesses for depositions, it's not necessary for parties, obviously. It didn't appear that way when you look at our forms, and they would have to put in under the other box where there's a line, they would have to write in depositions, and it really was confusing. And then we thought we could make it clear in both the rule and in the forms. So that is why we thought it was a good idea. It's always better to have good clarity. And I just thought it was a good point. I did work with Becky Schmidt on it. She probably has a little greater knowledge than I, if you need to hear from her, but I was in consensus with the court ops position.
And I guess the question is that is there any concern that making the amendments as suggested by Judge Bellis to 7-19 would cause any problems or be in any way inconsistent with the rules as they currently exist in 1326 through 28? Judge Armada?
But I suggest, first off, I'd love to get, Judge Diana to sign off on it again, but also if we could get Lori to see if there is an inconsistency, and whether we have to look at these viewed together, have somebody who looks at the practice book as a whole, because we don't want to create a problem.
Judge Griffin?
And I would just add to Judge Armada's point on not creating a problem there. It looks like just at the practice book that 719 is intended to address only hearings, and that 13 addresses the discovery process and deposition. So it might also, to your point, Justice Bright, add a layer of confusion there to intertwine the two when they've been treated separately, and more specifically in each section of the practice book.
So anyone else have anything they want to discuss? Judge Armada, do you want to make a motion then to do something at this point?
Would move that we table this to the November meeting to give Judge Diana a chance to look at the language proposed by Judge Bellis, and also to determine whether amending 7-19 is consistent with other sections of the practice book or creates problems.
Okay. Is there a second?
Second.
Judge Aaron, any further discussion? None. All those in favor say aye. Or raise your hand, sorry. Any opposed? No abstentions. All right, we'll refer that to for further comment from Judge Diana and for review by legal on the interplay of 719 and the other sections of the practice book. Okay. The next item on the agenda is 2025-011. It's a proposal for a new rule concerning notification to clients when a lawyer leaves a law firm. This is the first time it's being considered. It was proposed by Attorney Sullivan. In his proposal, he included a rule from Virginia, which provides some guidance. How would you like to proceed? Anybody have any thoughts at all? Judge Armada.
I would think that first off, before we change anything, we would need to have the Connecticut Bar weigh in on this, since it's a lot of practicing lawyers that this is going to affect, and they're going to have to put it in implementation. So I'd like to see what they have to say about it and their thoughts.
Anyone else? So, is it, Lori, did you have something you wanted to add?
I don't know if this is premature, if some of your honors were going to suggest this, but I would also recommend referral maybe to Bar Counsel or the Office of Chief Disciplinary Counsel at Judicial as well.
Okay. So is there somebody who wants to make a motion to refer this to Bar Counsel and to the CBA for comment?
I'll move.
Judge
So moved.
Armada? Is there a
I'll
second?
Second.
Judge Aaron? Any further discussion? All those in favor of the referral, please raise your hand. Any opposed? None. All right. Unanimous. We'll go to those two entities. So next up is 25012, which is a proposal to maintain the commentary to practice book section 10-35. The first time that's being considered. You have a memo from Lori which explained the reason for this suggestion. Any discussion, any motions?
I move to advance it to the public hearing.
Well, because it's a commentary, correct me if I'm wrong, Lori, we wouldn't send this to the public. Or with the judges,
Right.
wouldn't.
This is one of those rare occasions where it's just a decision for the committee, whether it's going to stay in the practice book year to year or not. So whatever you vote on that decision, that doesn't have to go to public hearing.
I don't see any harm or downside in continuing to include it for clarification purposes. So I would move to include it, to continue to include it, the commentary.
There's a motion. Is there a
I'll
second?
second Judge Aaron. I'll
Judge
withdraw
Armada.
mine and second Judge Aaron's.
Is Armada second? Any further discussion? All right, all those in favor, please raise your hand. And it looks unanimous as well.
Your Honor, can I just ask for clarification? Did the committee vote to keep both paragraphs or just a second paragraph?
What was the proposal? Was the proposal just the second?
I
paragraph?
kind of threw it out there like, you know,
At least,
I recommend at least the second, but you could keep the first, so I kind of kept it open.
I would keep both. The motion was to keep both.
Okay, thank you.
So how everyone else understood it as well? Yes, okay, all right. The next item is just miscellaneous. I have just one thing under miscellaneous I'd like to discuss. Judge Welch raised it earlier today with me, and that is whether we want to have any future meetings in person as opposed to over Teams. And Judge Welch, you want to kind of weigh in?
Certainly. Just, you know, in experience, I just think of the Civil Rules Committee, a lot of our, the Civil Jury Instruction Committee, a lot of our committees are done in person. And I noted that the only one here that's live is the public hearing. I always just find it's easier when everyone's in person in terms of the dialogue and the back and forth and the exchange of ideas. So I asked if there was a possibility that they all could be, or some of them could be in person. And I asked Justice Bright that. I just find in person to a better avenue for the exchange of information, exchange of ideas.
And I'll just weigh in on that, when I had my first meeting with Lori and Joe Del Campo about me taking over as the chair, I had asked about doing at least some of the meetings in person for many of the reasons Judge Welch indicated. I know way back when I was on the Rules Committee, being there in person made it easier sometimes to actually work on amending language, because you could kind of sit around the table and say, well, what if we put this language in, and everyone can look at it together and kind of come up with something that you can then vote on. It's a little bit clumsy to do that when we're all kind of sitting at our desk and we're not actually looking at language as it's being drafted and passed around. So I know that we used to have all the meetings in the Supreme Court courtroom, so that's easy for me to say because I can just walk downstairs if we did it here. We also, I think, having it streamed on YouTube is valuable. We will, I think, want to make it, if we can, in a location where we could still do the YouTube streaming so that the public has access to our discussions and easy access. But I throw it out to all of you, some of you who would be less convenient to meet in the Hartford area. And I'm not sure we need to do it every time, but maybe if we say we're going to do it, 3 of our meetings over the course of the year are going to be in-person meetings. When we're in the kind of thick of trying to get proposals done and voted on and set up for the public meeting. So anyone else want to weigh in?
I agree with the comments that you tend to have a more robust discussion and give and take when we're in person. I know I always find it a little awkward. I'm afraid I'm going to interrupt somebody who's starting to speak or just not sure where I am in the queue or that kind of thing. So I agree with that.
The only issue is whether, and it's easier. I agree with that also, but it's certainly more convenient and makes it much easier to attend when it's virtual, especially if there's a morning trial or there's things going on. And I think it's also weather dependent. So maybe if we did the ones in person, sort of spring and fall, and had the winter ones virtual, that might work.
Of course, we're still in the middle of summer right now, apparently.
I
but,
know, right? Today would have been perfect.
Yeah, right. Anyone else? We could add it outside. So, anyone else? I know Judge Torres, you have a little bit of a longer drive if it was in the Hartford area.
No, actually, I'm in Waterbury, so it's not terribly far. I think there's others that may be further, but I would welcome the opportunity to have it, at least some of them, as you suggested, in person. I do agree with the others that there is that a better opportunity to have that discourse when we're all face to face.
Okay. Yeah, the one, I agree, avoiding the weather issues would be great, except that weather issues are kind of when we're trying to finalize our work and get things done. So it might not be entirely possible, but how about if I do this? I'll go over the schedule with Lori and then send an email to you all, because I don't think this is something we need to take a vote on at a meeting, suggesting that a couple of the meetings that we do in person, and you all can check your schedules and see what they look like. And if we're planning out a couple months, that then gives you the ability to make sure you clear your calendar for that day with your presiding judge or your AJ. Okay, does that work for everyone? Great. All right. Does anyone else have any other business they would like to take up at this time? Seeing none, is there a motion to adjourn?
So moved.
So moved.
All right, second.
Second.
That's all. Say Judge Torres and Judge Aaron. We are adjourned. Thank you, everyone.
Thank
you.
Thank
Bye,
you.
guys. Thank you.
Thanks.